And so, Christian, you'll tell me when to start.
It's open now. We'll start seeing attendees to come into the room. It's starting to fill up right now, actually. Judge Butler, at this point of time, we are live, and if you want to wait a few 1 minute to let everyone join the Zoom meeting, but you're good to go.
Is everyone ready?
Yes.
Good afternoon, everyone. I am Tanya Butler, and I am the Magisterial District Judge in Northeast Reading. Today's program is entitled Issues of Habitability. We will discuss what is meant by the implied warranty of habitability, what are the breaches to the warranty, and when to assert it, and how it is applied in court. A huge thanks to our sponsors, the Human Relations Commission of Reading and the City of Reading, the Community Outreach Committee of the Berks County Bar Association, as well as the Reading Berks Association of Realtors. We would not be able to put this series on without your help, so thank you. And a big thanks to all of you. On behalf of myself and all of our sponsors, we welcome you and we thank you for attending. We have a great panel here, but before I introduce them, I do have some housekeeping matters to address. Since September of 2020, tenants were protected from evictions based solely on non-payment of rent. Many have heard that the CDC moratorium protections have now ended. There is still a lot of rental assistance money available, however, through the City of Reading Human Relations Commission, as well as through the Berks Coalition to End Homelessness. The City of Reading Human Relations Commission is able to take applications from city residents, and they are located in City Hall. And the Berks Coalition to End Homelessness is able to take applications from county residents as well as city residents. And the coalition just moved to the 3rd floor of the Berks County Services Center. If you are a tenant and you are unable to pay your rent or utilities due to anything remotely having to do with COVID, you lost your job, you lost hours, you were quarantined, you had to quarantine, please do apply for rental assistance through one of these agencies. If you are a landlord and you are not receiving rent, talk with your tenant, find out what the issue is. If it is something that has to do, again, remotely to do with COVID, have them apply, encourage them to apply for the rental assistance that is available. The applications are relatively easy and both agencies cover arrears, rent, and utilities. We will put the contact information for both agencies in the chat. Another item is we began this series with a discussion on Landlord Tenant 101, and we want to continue the conversation beyond today. If there is a particular topic within the realm of landlord tenant that you would like to hear about in the future, please put that in the Q&A and we will consider it. Also, the purpose of today's program is to provide basic information on landlord-tenant law. From a practical perspective, panelists will not be offering legal advice, nor will they be addressing specific cases. If any participants want to ask questions, please put them in the Q&A instead of the chat. We will monitor the Q&A and have a question answer period at the end. And finally, today's program is being recorded and live streamed on the City of Reading's Facebook page. Okay, I'd like to introduce our distinguished panel. Angela Tolosky has been a realtor for 21 years. She is the owner of Riker Realtors Neighborhood 1, where they sell and manage properties. Hello, Angela.
Good afternoon, everyone.
And we also have attorney Don Smith. Attorney Don Smith is a retired Berks County attorney after practicing for 40 years. Since retirement, Don developed a passion for ensuring the rights of tenants. On a volunteer basis, Don spearheads an eviction prevention pilot program in my court and works with Mid-Penn Legal Services representing tenants in landlord tenant actions. Good afternoon, Don.
Good afternoon, Judge, and thank you.
Okay, let's get started. We'll set the stage so that everyone is on the same page as far as what we are talking about. I run my landlord tenant hearings the same way. After I swear everyone in, I ask the tenant background information. I ask them how much, where do you live? How much do you pay in rent? How much do you pay for a security deposit? I then turn to the landlord and say, okay, you filed based on non-payment of rent. And we're putting COVID aside in this rest of this discussion. So I'll say, you filed based on non-payment of rent. And the landlord will say, yes, I'm owed 1 month, 2 months, however many months. So, and sometimes there are late fees in addition to that. I then go back to the tenant and I'll say, your landlord stated that you haven't paid rent in, let's say, 2 months or 3 months. And the tenants will say, yes, that is true. I did not pay my rent because of the condition of the property. Then I'll say to the tenant, okay, what's going on with the property? So Don, so that's just a background of what we see as MDJs and how that the issue of habitability comes up in our courts. Don, I'll begin with you. What is meant by the implied warranty of habitability?
Well, let's focus right now on the word habitability as you've touched upon. And it's been defined as the ability of the premises to be used for human habitation. And it means more than just shelter. It has to include, habitability includes all of the basic needs of a modern dwelling. First, it means it's secure, and it provides, as well as being secure, it provides the basics of human sanitation. And those needs such as running potable water, hot water, heat in the winter. And the unit to be habitable has to be free from vermin, rodents, infestation. And it has to be reasonably weatherproof. We don't want a bunch of leaking water, especially on a day like today. Habitability also means that the leased premises are free from defects or conditions that unreasonably subject residents to a risk of harm to them and their property. So that's habitability.
Okay, and Angela, what Don described, is that something that is automatically in a tenant's lease, or does that have to be spelled? Does the tenant have to ask for that?
So the leases that I would say majority of the realtors use is from PAR, Pennsylvania Association of Realtors. We do have a residential lease, and there's also a commercial lease. The residential lease, which I went back through thoroughly just to see if there was things that were spelled out about habitability. And actually it's not worded anywhere in our lease. There are other things though that talk about just the condition and if there's any damages. If you're starting from the beginning, when they first take possession, I would definitely suggest that the tenant should be walking through the property with the landlord or the property manager before the lease starts. There is sections that spell out, possession, which is paragraph 10, talks about the start date, them taking possession, and does talk about if the property has any damages, that they're able to, or is in condition, they can move right in. In that section, it only clearly just talks about whether or not there's damages, if they would need to delay or want to change the start date, which that would be my first suggestion, that if it was not able to be habitable the day that they signed the lease, that they were supposed to move in. So it was supposed to be, September 1st, and they go to move in, and it's not, does not meet all the items that Don had mentioned with having the drinking water and having hot water and shelter, then they should change their start date to help to not have these issues. As soon as they move in, then they don't want to start paying rent already. And they might already have paid their first month's rent security before even this has started. So that would be my first suggestion, to walk through the property and make sure it is habitable for them to move in. I don't know if we want to talk about now or later, but our lease that we have, there is no clause that they can stop paying rent. They are responsible to pay monthly, regardless of the condition, if of course, by state law or by the township or borough that they have said that you cannot be in the premises because of damages or casualty of loss of fire from fire. So then it gets into a whole other can of worms. But I don't know if we want to talk about that now or later, but if no one from a township perspective, or if there no other law, provision has said they can't move in, or they should not have to keep paying, the lease, our residential lease does say that they would continue to pay monthly regardless.
I just, if I may, Judge, I think Angela's touched on this, but just to make a clear point, this warranty of habitability doesn't have to be set forth in a lease. As of 1979, the Pennsylvania Supreme Court has held that every residential lease, written or oral, has an implied warranty of habitability, and it cannot be waived. So Angela's referred to one of the standard leases. I can tell you that no lease, even if it attempts to waive the warranty of habitability, that is not enforceable under Pennsylvania law. I've been in Judge Butler's courtroom for almost 1 year now. We started the program on September 8th, and I don't know, Judge, we must have been through at least 400 to 500 cases in this past year, at least. I've seen one lease that even touched on the warranty, and it was really to set forth what's required by the tenant in giving notice. And we'll talk about that in a little bit. But I just want to emphasize, Angela kind of touched on, but I wanted to emphasize the lease doesn't have to warrant the habitability. It's deemed part of a lease, written or otherwise.
True, and that brings up the idea of implied, right? It's a warranty that is implied. So since we're talking about the habitability issues, Don, what are some examples of some damages that would represent a breach of that implied warranty of habitability?
This started, as I indicated, it started with a 1979 decision by the Pennsylvania Supreme Court. And they found that as I said, every lease has the implied warranty of habitability, every residential lease. It did not really set forth examples of what types of damages, but it did set forth 3 factors to consider. And it's a case-by-case analysis. The judge has to make a decision. Is this damage enough to breach the implied warranty of habitability? And those factors are whether or not there are housing code violations. What's the nature of the defect and how serious is it? And what's the length of time that the defects have existed? So basically, I can run through a list of examples that we find in treatise in say the Pennsylvania Treatise on Landlord Tenant Law, that these are considered good examples of breaches of the implied warranty of habitability. And those would be the lack of potable water on the premises, or the premises not having any locks or a means to secure the premises. And there's for example, a defective waste disposal system that poses a health hazard. I might add here anecdotally, one of my first cases that I encountered when I first started in 2019, volunteering with Mid-Penn to represent tenants facing eviction. The basement of this rented home was flooded with sewage. And the tenant complained to the landlord about it, and I'll get into this later, but the landlord's response was, "You and the kids poop too much," and that. But we went to a hearing based upon that's a serious, and it clearly is a serious damage. Also, a common one that we have seen is an unsatisfactory heat situation at the premises in cold weather, or the premises are not weather or waterproof. For example, the windows aren't tight, or the windows are broken, not through any fault of the tenant, or there's leaking going on, as I've indicated before. Also, pest or vermin infestation is a clear breach of the warranty. An unsafe structural component. I just recently have heard of a case where the tenant stepped out of the shower and onto the bathroom floor, and the floor collapsed, sending her to the level below, causing very serious injury. The tenants had complained to the landlord about the poor flooring in the bathroom, and it was never fixed. Lack of refrigeration. If the landlord has provided the refrigerator under the lease, if there's a lack of refrigeration, that obviously affects the habitability. Or inadequate electrical wiring. That's not a safe situation at all. And the court in Lancaster County has found in 1992 that not having fire warning devices was a breach of the warranty of habitability. And another condition that I would submit that we talked about at the last seminar in Landlord Tenant Law 101 would be the lead paint hazard situation. Reading, as the newspaper reported earlier this summer, Reading has children with elevated blood levels 2.5 times higher than the rest of the state. And under federal law, if the building, the rented premises, was built before 1978, federal law requires that the lead paint hazard situation, whether it exists or doesn't exist, be disclosed in the lease. And Angela at that time talked about how her standard lease does provide for that notice, as well as the pamphlet. That though, the lead paint hazard can be could be a breach of the implied warranty of habitability. So it's on a very basic level. The warranty is breached if there is a defect of the kind and nature which prevents the premises from being used for its intended purpose of being fit for human habitation.
Thank you for your response. Angela, I sometimes hear landlords say, once the tenant has gone through any of those, and sometimes it's a lot of those conditions, I've heard that the landlords, some landlords are saying to the tenant, I will fix the issue with the flooring, for example, or I will fix the holes in the wall so that there are no more rats or roaches coming in. Or I will fix the issue with the sewage if you pay me the rent. You're not paying me the rent, so I don't have the money to fix all of those issues with the property. Is that appropriate?
I hear the same things that you're saying. That's definitely, I deal with a lot more landlords than I do tenants, being with property management. So not that it's appropriate, but that is definitely the response that I think most landlords think, that they are owed the rent and then they can make the repairs. One thing I find, and the lease covers a little bit of this too, with maintenance of the property. And the tenant, when they sign the residential lease, the PAR lease, they're supposed to, with it immediately, let the landlord know or the property manager know if there are repairs need to be made to the house. Now, one thing we really haven't talked about here is, when is this coming up? Are these things of being habitable? Is it in the beginning? Is it towards the middle of the lease? You know, what point? Does it make a difference? Yes and no. And like I said earlier, you know, if they've walked through the property first and it's from the get-go that there's issues, then I think that they need to be addressed right away. But what if this is something that has happened 3 months into the lease or 6 months into the lease? You know, under destruction of property, paragraph 19, it talks about that the tenant will notify landlord or maintenance, whoever is handling maintenance, property manager, immediately if the property has some sort of damage, if there are repairs that need to be made, that then he or she is supposed to come out then and address it immediately. But it starts with the tenant giving the notice to the landlord. Now, I don't know if you get into that, you know, asking, when did you give notice that there was an issue? You know, that's probably a great conversation to have too. Was it made aware to the landlord that these issues occur? And Dawn, you can touch on this too. Many townships and boroughs here in Berks County, they have that the township has to inspect the property, because there is a rental inspection that's required before it can be leased again, and or sold again. You know, a lot of times when I'm getting these as brand new landlords that I'm starting to represent as a property manager, and it might have just gotten inspected by that township. And you would hope that a lot of these items will fall into the township's list of things that need to be corrected in order for it to even be rented. So I guess from my standpoint, on some of the townships and boroughs, like the city of Reading, Spring Township, you know, some of these townships that have these inspections already in place, I'm hoping that by the time I get the property, it is habitable. I don't have these issues, and wouldn't have to worry about the tenant not having running water or infestation or leaky roof, you know, those type of things, because they've been covered. So, but on my side, it always starts with the tenant immediately giving notice to the landlord that we're able then to look at the items and repair them within a timely manner.
Okay, so you would suggest to a landlord that it's okay to wait for the rent before the landlord would repair the issues that come up with the tenant?
I always, as far as property management goes, we always, since we're handling it on the landlord's behalf, automatically, we don't have to go to them for their approval to get the repairs made, because we automatically have it in our property management agreement that when we get notice of the issue, that we're going to address it and that it has to be paid. So it's not even in our property management agreement that we are going to wait for rent. before the item is addressed and repaired. And so that's automatic. Now, those that are not represented, I do hear the same things that both of you hear, that, well, we want the rent first and then we'll make the repairs. On our end with property management, we don't handle it that way. We automatically address the issue, have the property manager go out, look at what the item is, and or call for, whoever it might be that needs to come out and repair the item immediately. And then our landlords get charged for that from the rent that we're receiving. They automatically get charged then. It's taken out of their proceeds at the next payment.
Of all those cases that we've had in the past year with Judge Butler's docket, Angela is the exception. Unfortunately, there aren't all that many that I've seen that are being professionally managed in such a great way as you're doing, Angela. And some of it, there's a large portion of them mom and pop landlords. But I can't emphasize, just to get back to the point I think you're making, Judge, I can't emphasize enough that under that 1979 Pennsylvania Supreme Court decision, landlords cannot withhold rent or cannot withhold making the repairs because the tenant has decided not to pay the rent. In fact, the court has said the covenants and warranties here are mutually dependent. If the landlord doesn't provide a habitable dwelling, of course, that's the issue here. If that habitable dwelling hasn't been provided, then the tenant doesn't have to pay rent. Pure and simple. Well, it's not so simple, because then we're going to get into the issue of have we established that it isn't a habitable dwelling?
All right, Don. Oh, I'm sorry, go ahead.
No, I was going to wait for your next question.
All right, Don, when we established that there's some issues with the property, the tenant has made the decision, I'm going to withhold my rent. What should the tenant do next? Like, how does the tenant enforce that warranty?
Yeah, I mean, even before the tenant, I would caution the tenant about withholding rent right away. Instead, there are two basic requirements in order for the tenant to enforce the implied warrant of habitability. The first is to give notice to the landlord, and it's preferable that notice be in writing. Now, in today's world, that writing could be an email. It could even, and we see this a lot in Judge Butler's courtroom, it could be a text message. Sometimes, and I've seen this too, that the landlord is on site and the tenant has pointed out the mold on the wall or the leak or the fact that the stove that was to be provided by the landlord isn't working. But yet the landlord doesn't take any action on it. But of course, I, as an attorney, I would strongly recommend that tenants provide that notice in writing, because then you have something to document. If it comes to that time for a hearing, you can document that the notice was given. The second requirement is for the tenant to wait a reasonable length of time. And that reasonableness can vary depending upon the circumstances. And I think you wanted to talk to, or I guess ask Angela, her view on what's a reasonable length of time.
All right, and I do, but since we're with you, what do you think is a reasonable period of time for the tenant to wait?
Well, that varies upon the circumstances. If the heater is no longer working in July, I think the landlord can take some time to fix the heater. But if the heater is suddenly failed on a very cold day in January, I don't think much more than 24 hours is a reasonable length of time. I think it goes to, and then there's also the issue, if say it's a hot water situation and the landlord comes in and says right away and says, oh, I see what I need to do here, and I need to replace a part. and he goes to the hardware store, whatever, and they have to order it. So then I think then a reasonable length of time would be to get that part that wasn't available at that moment for the landlord to receive, a length of time to allow for the landlord to receive that part. However, if the landlord chooses not to fix a water heater because it's too expensive, then it doesn't take those remedial actions, then I think that changes the length of time to be much less.
Okay. And Angela, you already said that your company, you all will go out immediately and look at the issue and address the issue. Is there a particular window of time that you think that landlords or property managers should respond within?
Yeah, I definitely think within 24 hours, at least a verbal response of what they're doing, what is the plan here? I did find, because of COVID through last year and this year, it is harder to get parts. I have found that it's even harder to get appliances. A refrigerator goes, not so much now, I think it's better, but last year we had through Lowe's, a major company that was not able to get us a replacement because it was a smaller refrigerator that could fit there. So we were limited to our options. And it took like 3 weeks to get a new refrigerator. And it caused us to try to start calling all the appliance places, try to even see if we can find used until a new one could come in, because that's how backed up they were and did not have the items in stock. So right now, it seems like there's more of an issue the last year than what there had been previous as far as getting appliances. We just had last year, someone moved in, we just took possession of the property, our landlord just bought the property, and the kitchen cabinets fell down. Not kidding. This is my first time I ever had that. Literally, the whole section of cabinets came down. The tenant took pictures of it. So I thought of it when you were talking about, giving writing and giving written notice and having text messages. They sent us text messages, pictures of the kitchen. So that was a matter of, calling our contractor to come out. Some of them were damaged that we couldn't just fix them, so we had to get new cabinets. So that was interesting because I never had that before, and we were trying to move quickly on it because here the entire kitchen was in disarray and they couldn't use anything. So there's sometimes these oddities that come up, but the biggest thing I think is there's a gray area there. And Don, maybe you can agree with me that there's definitely a gray area when you say in a reasonable time. We have so many things in our contracts that say within a reasonable time, whether it's returning deposits within a reasonable time. It's just gray because each person's idea of that can be different. So I think with these emergency calls that we get, I think within 24 hours, they need to be addressed. And this is just a personal opinion of that, because like I said, everyone has their own opinion of a reasonable time. So, with property management, I think, it's definitely great if the landlord has someone helping them, because many of them, they might not live here. And that's a big problem I find. They're out of state. They don't live locally. And so if they're handling their own properties, they're going to need someone that, and maybe this comes up in your courts as well, who is managing your properties? Are you the one that's taking care of these items? Because if they're not here, then I do think that a reasonable time can definitely be extended longer than what it should.
Okay. And you brought up a good point with the pictures and video.
Mm-hmm.
I love when a tenant comes in with pictures and or video, because the tenant will be saying that they have, like the example I gave before, holes in the wall or mice are walking around or crawling around the kitchen, and the landlord would say, no, that's not true. I've been there, I've never seen that. And the tenant pulls out the video showing like day after day of just, the video of the mice crawling around, or it shows the pictures of the holes in the wall, or shows the picture of the roof leaking. or a video of the roof leaking, that is very helpful to an MDJ in making a decision.
Yeah. Let me just add one more thing too. On the flip side of this, that, you know, of course, we all want the properties to be habitable for tenants. One issue I do find, and this is even just showing properties that tenants live in, the biggest issue I find is that they don't always allow us access. Like our leases state that with just as long as we give a 24-hour notice, that we have the right to walk through the property. And we tell our tenants that we will be coming to the property. I like my property manager to go through at least twice a year. If there's no issues that come up, just to give them notice and at least walk through the property if everything's going well. We've been very fortunate to have some really great tenants. Our screening is very detailed. There's so many tenants looking for properties that it makes it easy for us to try to find the best person for the property. But sometimes though, I do find if there is no issues going on that they think the tenant believes is an issue, it is hard sometimes to get in the buildings. That I will say, I do find they change locks without permission very often. When we take over properties, we don't even have keys a lot of times because the previous landlord has left them change the locks, and then we don't even have keys. So sometimes it's maybe I'm biased to landlords just because I have issues getting in these properties sometimes, but that's the other problem I have with looking at the condition of the property.
Yeah, and I'm certainly not going to take issue with that. We always advise tenants that whether it's set forth in the lease or not, the landlord owns the property or has the property has designated the property manager, as long as proper notice is given, and you can work out a convenient time. I mean, we've had some situations where the tenant was not cooperative and saying that, you know, when the landlord wanted to show up, there were going to be children there, and that she wasn't able to be there at the same time, or, you know, she's at work and they couldn't work out a time. But and that's where Judge Butler, I think, is very good in these cases. And when unfortunately it takes filing an eviction complaint to get before her to get the parties to communicate. As the judge indicated right from the beginning, there should be communication between the landlord and the tenant right away. We should not be ending up with an eviction complaint being filed unless it's, you know, for a legitimate reason and not simply because of a breakdown of communication. And Angela, the other point I wanted to make, not to stir the pot here, but I take a little exception to you allowing New York-based landlords extra time. I mean, unfortunately, I mean, there are too many New York landlords in Reading. And in fact, God, I've got this case right now where he's refused this. It's filed in common pleas court, actually. And he's, unfortunately, he didn't even hire an attorney to represent him on the other side because he's above the law. He basically is saying he's above the law. And it's a Brooklynite, and I'm finding it difficult to deal with him. Yes, I mean, I realize they're not in Reading, but they should have someone designated to deal with these kind of issues. They've got someone designated to collect the rent. They should be designated. They should have that, if not that same person, someone else. Because habitability, if it's truly a habitability issue, that's not the tenant's problem. That should be the landlord's problem, and should be. I don't give them extra time under the reasonable analysis just because they're living in Brooklyn and hoping to make money off Reading tenants.
And I believe, I know when I was in the solicitor's office at the city, there was an ordinance that required property managers or landlords to have property managers if they lived a certain distance away. I haven't followed up on that since I left the city, but hopefully that ordinance is still in effect.
That should be in all areas. Absolutely.
Yeah. I have a question for you all, either one of you. when we're talking about condition of the property, sometimes I have, Angela, you brought up, we hadn't addressed at what point the tenant is having the issue in the property. But there have been times I've had tenants say, there are roaches everywhere. And that tenant has lived in the property maybe 9 months, 10 months. So this isn't a tenant who has just moved into the property. And the landlord will say, if there are roaches, it's because of how the tenant is living, how the tenant is maintaining his or her property. I ask either one of you to address that. Do you believe that it's on the tenant to clear the roaches in that situation, or is that a thing to complain to the landlord about? Angela?
That's a tough one because, if I walk through a property and see that there is food everywhere on the ground, I would put that back on the tenant, that they would need to clean and not have so much, food or other things that are accessible to rodents. In our lease agreements, it doesn't talk about that. The agreements that we use, the boilerplate agreements that we use, doesn't really talk about that. So, but I do think that, now I don't know, I know there's a problem in the city with roaches in some areas. I had a customer buy a property that the neighbor came out and said, hey, just so you know, this whole block has issues with roaches. And so, so on one hand, I want to say, if that's something that we can notice, that's noticeable, that the tenant is doing, then should they be the ones to pay for it? If it's not in the lease, if it's not written in there what they're going to maintain as far as utilities go, or as far as lawn maintenance and regular cleanup, or if there's already a pest control company that's contracted, if that's not put in the lease, then I would say that the items will go back on the landlord. But I know some of the agreements I've seen, they do have those kind of things spelled out as far as who was going to be the one to pay for these things. Also, one thing we haven't touched on at all is some cases the landlord has a lease and a purchase built together, as though, if the landlord has offered to the tenant to buy the property, then a lot of times we write in that the tenant's responsible for everything. Because if he has a purchase lease agreement in place together, and within 1 year, it is promised or signed that he's going to be buying the property, then in most cases, the landlords expect that the tenant is going to pay for everything of the property, because now they have an interest with the purchase of it. So
it sounds like that type of thing should be spelled out. Who's for pest control issues? Don, you were going to say something?
Yeah, I mean, Angela just touched on the rent to buy situation. We could do a whole program on that, because I've got some strong feelings on that. Because that, frankly, not in Angela's office, but that's a problem in the city, and it is especially a problem in various ethnic communities, and relying on notary publics, and I could go on forever venting about the abuse that can occur with rent to buy agreements. But anyway, to talk about a roach problem or a rodent problem, I agree with what Angela was saying. You don't know, and the leases that I've been seeing with the less professionally managed properties don't really touch on it in the detail that Angela has talked about. But I would agree that if the roach problem is isolated to, say, the tenant's apartment, and it's because of the situation she described, it's really the tenant's fault, then it's on the tenant. But if this is an apartment building, or it's a situation where the entry isn't is more the landlord's problem than, and not limited to just the tenant's premises, then it's definitely on the landlord.
Yeah, one more thing I was going to mention, I saw in the chat box, Alicia made a comment. She's right. Paragraph 16 of our PAR agreements does have a spot that you can check landlord or tenant responsible for different things. And there is a box there for bed bugs remediation and pest control. And you would just check the box as to who's responsible for those items. Like I said, along with the other items too, the electric, the trash removal, lawn care, and maintenance. And then you can add additional things for, other types of maintenance that have to be done to the property. So it can be spelled out in the agreement that most realtors use, not all. Some landlords have their own leases, but the ones that I use, there is a section that you have it spelled out.
All right, thank you. All right. When the tenant is describing the situation to me that's going on at the apartment or the house, sometimes it seems as though the condition is throughout the house. Other times it might just be limited to one room of a house or one area in an apartment. And so my question to either of you is, if the lease property is not totally inhabitable, how does one calculate a partial inhabitability?
Judge, before we go there, could we first discuss the remedies that are available to the tenant generally when dealing with a breach of the warranty of habitability?
Okay, go right ahead.
And there are several different ways that the tenant can attempt to enforce it. The first is terminating the lease. If the condition is such that living there is simply not habitable, the tenant can give notice that they are surrendering the lease and leaving a forwarding address, turning over the keys. And in fact, I wanted to point out that in the Pennsylvania Landlord Tenant Treatise, there's a Berks County case that is cited. It's Magisterial District Judge Eric Taylor had a case in which he actually wrote an opinion that was published in the Berks County Law Journal back in 1989, in which there was black mold in the property, and the tenants and their children were getting sick, and they thought it was from the black mold. And Judge Taylor found that the landlord did not respond as timely as she should have to a black mold situation, and found that the tenants properly terminated the lease early. Now, we're not talking, terminated it early. And what the landlord did there, and what caused this case to get in front of Judge Taylor, was that the landlord took the unpaid rent then out of the security deposit. And the tenants filed their complaint with Judge Taylor to get the security deposit back, and he did. He awarded the entire security deposit because it was a proper. He found a breach of the implied warranty of habitability, and he found that withholding the security deposit or reducing the security deposit by the unpaid rent to the end of the lease term was improper. So that's one example where the tenant, an action that the tenant could take. The problem today with the pandemic is how easy is it to find another place. And so it's not easy. It's not probably the best option for a remedy that the tenant could employ. Another option that they have is to make the repairs. The tenant could make the repairs and then deduct the cost from the rent. And I've seen that attempted in a rodent situation where the tenants actually got impatient and paid for some type of infestation elimination, and then deducted that from the rent. But in doing whatever you do in that regard, it has, once again, you always have to give notice to the landlord as to what is being done and why that portion of the rent wasn't paid. And I'm not sure how practical that is even, because sometimes the rent, the repair costs are so high. So, but if a tenant does attempt that, number one, they have to be able to show the need to do that. And the best evidence for that is to call in city codes or municipal codes to do an inspection to document the problem. And not only do you have to show the reason for it, but it has to be a reasonable then repair. And so the best evidence to show that would be that the tenant received several estimates as to what was done to repair, to make the repair. There's also a third remedy would be to sue the landlord for damages. And I've never seen that, at least in Berks County. And I'm not quite sure how practical it is. And then there's also the equitable relief, as one writer has included that as a remedy, and that's the specific performance, to get an order from a common pleas judge requiring that the repairs be made. I think for most tenants, that would not be a practical. So what we normally see then, the most common and what we've only ever seen in the last year in Judge Butler's courtroom is the withholding of rent. And of course, they're withholding the entire amount. To get to your point here, Judge, about what if the alleged damage is only causing a portion of the rented premises to be uninhabitable, as opposed to the entire residential premises. How do you handle that? But what we're seeing is, going into a hearing, we're seeing is that the landlord or the tenant has withheld the entire monthly rent and continuing. Now, to do that, they can't just spend it then on something else. They have to set it aside. The best, of course, is to put it into an escrow account. But how many people these days even have bank accounts or checking accounts? And but that would be the best approach. But as long as it's set aside. Now, in the last year, I've had one tenant come in that they actually did open a bank account. Another tenant, when I asked, have you set aside the money? And at that point it was $4,000 that was owed. She pulled it out from her bra. And I said, okay, well, that's good escrow. I wasn't going to question that. But the point you were trying to make, or you were asking about, is what if, say, for example, I had a case a couple years ago, one of my first cases with Mid-Penn, where it was a 4-story dwelling and there was no heat on the first floor. And they gave notice and they complained about it, and it was never corrected. And then what happened was there were other issues, and we ended up in arbitration, and they had left the property, they moved out. This was before I was representing them. And the landlord wanted more money than the security deposit, claiming damages. And so we counterclaimed, saying, well, you've got to reduce it by the fact that there was a breach of the implied warranty and habitability. And being a reasonable person, I figured it was 1/4 of the rent, because it was 1 floor of 4 floors of rented premises. So 1/4 of the rent should have been withheld and dealing with it. Now, the treatise, the Pennsylvania Landlord Tenant Treatise, talks about 3 methods. One is the difference in fair value. And then the second one is a percentage reduction in use, which is what I applied. And then a third has never been used in Pennsylvania, but the writer of the treatise says it should be one that's considered, and that is to not to look at the concept of fair rental value and how much it's been reduced, but also to make an award for the tenant's inconvenience and annoyance. And the example this writer provides is, what if the issue is the dwelling had no hot water and the tenant had to go to a gymnasium of the nearby university to shower? There may not be any actual out-of-pocket cost involved with that, but there's a clear inconvenience. And so he makes a point, though, the treatise writer makes a point of saying, this hasn't been adopted yet by any Pennsylvania court, but he thinks it's one to consider. So I don't know what Angela's experience would be, but I kind of like the percentage of use. Now, when I brought that up with tenants and said, well, this I see that the leak situation, the mold situation. In fact, we just had a case where there was bad mold in the daughter's bedroom, and so the mother, to her credit, moved the daughter out of that bedroom, but she was forced to then go into that bedroom. When I brought this issue up about, well, what's how much should the rent have been reduced? She made a very good point of saying, where else am I going to go right now? And Angela talked about how she's being swamped with rental applications. I mean, there's a shortage of rental premises now, and not just in the city, but in the county. So it's difficult. And so I would suggest the effects of the pandemic have to be considered.
Thank you, Don. Angela? Anything else?
I don't have any comments on that. It's just other than, when we talk about some of these hazards, it's not, well, lead-based paint being one of them, it's not required for the landlords to, or even the tenants to have it tested. So for lead-based paint, or mold for that matter, but with lead-based paint, like we talked about that earlier, the biggest issue with that I find is that when a landlord has to disclose, then in most cases I'm finding they're disclosing that they have no knowledge because they've never tested. Most people don't test, I think, just because of the expense of it. They're, whether it's the expense from a new buyer or a tenant that doesn't want to pay for it, but also, most landlords then will look at the cost to remediate. If a tenant wants to test, then it could be, far more expensive to remediate rather than just not test and just paint over. I hear that quite often. Oh, well, we're just going to paint over it anyway. That's what I hear quite often. And so often I don't see that people are testing for these things unless they've already physically seen evidence of molds, or they see so much chipping, peeling paint and it's, home in a city built in 1912 where they figured it probably could be lead-based paint. So, as far as the hazards go, unless you can physically see it, I normally don't see that those kind of provisions are asked to be tested or asked to be remediated until the problem gets to a point where, like this case is that Don's saying, where you're having an issue with probably the tenant getting headaches, or, you can smell it, things that you can physically see and it's affecting you physically daily. So.
Right, and in the case that Don talked about, I believe the mother complained that the daughter was having issues, was getting sick. So yes, we see them drastically. Don, also with your point with the tenants providing the repairs themselves, it's important for tenants to keep all receipts.
Oh, yeah.
So
yes,
that
thank you. Yes.
Because you have tenants who will say, I paid for this, I paid for that, it cost that much, I lost the receipt. I gave the receipt to my landlord and I didn't keep a copy of that. So for tenants, you want to hang on to the receipt. If you give the receipt to the landlord, give the landlord a copy of the receipt. Make sure you keep a receipt. Angela, were you about to say something?
Oh, the only other thing that I didn't know if you want to touch on, I know it's already 12:58, but one thing that our leases also talks about is destruction of the property. If it's been destroyed after they've moved in, and if it's found that it was something that was caused by the tenant. I recently had a situation where the tenant, they found that from smoking, they had caused a fire. And so there was major fire damage in the property, and they found to be the tenants that the tenant was negligent for it. The landlord immediately evicted them. Now, we didn't get into, they chose to move without any issue. And now we haven't gotten so far as to, I don't know, additional rents going back to, for payment to the landlord. That hasn't happened yet. But, in that case, they were totally at loss, and the insurance company, the renter's insurance that the tenant had did not cover, because they felt it to be that they were negligent for it, and it was, it wasn't a situation where it was faulty wires or other things. So so there was no insurance coverage either on it. So we didn't get into that. I don't know if we want to go down that that rabbit hole, but I would say the other big item is what insurance is on these properties. Is there homeowner's insurance being kept on it? Is there renter's insurance? Can any of these issues that are currently going on be covered under an insurance policy? It would be the only other thing I would say should be looked into. And we should always make sure that each party has insurance. Especially if there's, if we're talking about major roof damage, or what if it's damage that's been occurred because of a hailstorm or a tree falling through the building. So I think there's other things, and maybe you don't see those cases as often as you plain see this is just negligent on a landlord or on a tenant, if it's that clear cut.
We could definitely address the need for insurance in a subsequent discussion on landlord tenant issues. And the renter's insurance is huge. A lot of people, they see it, but they don't go out and take that renter's insurance, and that's so important.
Yeah, and it's so inexpensive. It's so inexpensive.
Yes. Yes, you're right. Don, were you going to say something, or can we move on?
Well, I just want to, the other remedy that a tenant could have is to make a claim under the Unfair Trade Practices and Consumer Protection Law in Pennsylvania. The Pennsylvania Superior Court has held that residential leases are subject to the Consumer Protection Law, and there is actually a case that the landlord's failure to make the repairs in light of a breach of the warranty of habitability was so egregious that the common pleas judge awarded triple damages to the tenant, and that was affirmed on appeal. So that, and in fact, just 2 weeks ago, I had a hearing in a case in which I'm claiming damages under the Consumer Protection Law for a breach of the warranty of quiet enjoyment. The judge hasn't rendered the verdict yet, but I think that's a remedy that has not been frequently enforced in Berks County, but it's one that's out there that landlords should be conscious of, and it would be another reason to move promptly in this area.
One more thing I just want to mention too, Judge, is that like I said earlier, many of these townships and boroughs do have inspections. I don't know how many tenants, though, truly realize that they can call into the zoning office, they can call their local township and see if there is an inspection in place, and try to see if they can get the township or borough involved and come out and look at the property, because there could be violations that could be imposed on the landlord. So I would think that would be something that could be a quicker way. Maybe it's not perfect, it's not exactly what the tenant would want, but it might be a way to get a landlord to comply if the property was not habitable.
I do think in the city of Reading, at least from our experience, that tenants are generally aware of that.
Yes.
And that was going to be, if we get to the question of litigating this case and how the tenant should defend a non-payment of rent based upon where they have not paid the rent based upon a breach of implied warranty. It really does help to have the city have made an inspection and cited and made a citation. I will caution that that in some cases, in fact, the one that I just litigated, it's the landlord then retaliated, and that was the reason, not the spoken reason for the eviction, but everything else was clearly just bogus. We were able to, in summary judgment was granted, holding that it was a retaliatory eviction. But that's another, that's another story to go to. But I do think you're right, Angela, that it would pay the tenant when these issues, certainly when there's serious issues affecting habitability, city code should be advised.
Right.
It makes proof a lot easier at the time of the hearing then too.
Yeah.
For the city, it's the property maintenance office, which is located in City Hall, on the first floor of City Hall. You raised the next topic and our final topic as far as, so the landlord, the tenant has properly given notice of the conditions of the property. Landlord has not fixed the repairs in the reasonable amount of time. And the landlord has now brought the tenant to court for an eviction based on non-payment of rent. Tenant brings up the issue of the condition of the property. How does the defendant assert the implied warranty of habitability? And does that tenant need to be represented in court in order to do so?
Well, now you've asked, your question is similar to asking a barber, do I need a haircut? By asking a lawyer, is a lawyer necessary? No, a lawyer would not be necessary, but boy, it sure is nice to have a mouthpiece and having an attorney who knows their way around the courtroom, especially on this issue. And so I would definitely recommend having an attorney, and if I could just, the Berks County Bar Association has a lawyer referral service, and I can throw out that phone number. It's 610-375-4591. If the tenant feels that they cannot afford an attorney, that we do have, we're fortunate to have Mid-Penn Legal Services with an office here in Reading, and there's a phone number for them. It's 1-800-326-9177, or they can apply online to see if they're eligible for a free attorney. And that website is apply.midpen.org. But yes, a tenant could handle this on their own. I would recommend that you start off by showing what the damage is. And the best thing to do is to have pictures of it, and then a description of how that has affected the tenant's ability to live on this property, the extent and scope of it, and then showing how notice was given to the landlord, a copy of the text message or email, or testimony that she or he has pointed out to the landlord when the landlord was on site, and then describing the length of time that has passed, and confirming that the rent has been set aside, whatever that rent payment would be due at that point. And then, as I said, you get to the question of calculating damages, and we've talked about that. But I would assume that they've withheld the full amount of the rent, and then the judge could ask questions about that. But I commend you, Judge, because at this point, usually you would turn to the landlord and say, well, what's your defense in view of that? And of course, what we've seen, at least what I've seen frequently, is why I didn't know about the problem.
Right. All right. So Angela, what would that defense be? Or what's the landlord's or property manager's response to tenants who have asserted their warranty of habitability as a defense?
Well, 100%, you know, from my point of view, as a realtor and in real estate, all of us that are in the same realm that I'm in, if we get to this point, we need to stop trying to assist, because I think, you know, once you give suggestions to the landlord what they need to do, give suggestions to the land or the tenant of how they can help their situation. If neither one works, then in the end, they need to seek the advice of an attorney. They need to get legal counsel, because since I'm not an attorney, I can't give legal counsel. And I always say that to them. You want to help. I want to help always as best I can, but I don't ever want it to be that I'm giving legal advice that's why I always quote from my, from my lease. I quote from the paragraphs that I know of things that they've signed, whatever they've signed. Well, this is what you're responsible for. This is what he or she's responsible for. And that's as far as we're able to go and as far as we should go. So I have a couple of attorneys that I know do real estate. I always suggest to people, find someone that knows real estate law, that knows Tenant Landlord Act. And I jotted down too, as well, the information that Don is giving. I think it's so important. And I do think often for these tenants, they don't have the funds to hire someone and pay thousands of dollars, or to be able to give the retainer that's needed. And so having these services, whether free or at a reduced cost, I think is so important. And they need to at least try. If they've exhausted all their options for themselves and cannot live in a property, then they need to hire an attorney, 100%, and get that, as Don mentioned, get that, voice to stand for them, because they're not going to know what to do. They're not going to understand, what their rights are in many cases. So that is our first suggestion every time.
And not only sometimes do they not know the law, they don't know when to shut up. And they talk when they shouldn't talk. It irritates the judge, and they don't know how to cross-examine. So yeah, you could, as a tenant, and even as a landlord, you can do this on your own, but it goes so much smoother, doesn't it, Judge, from your perspective, if counsel are involved, who know not only the rules of law, but the rules of etiquette.
Yes, it does. But like you said, or I think Angela said, not everyone knows that they can have an attorney, and they may not have the money for an attorney. It also helps if the tenant is in front of me and they are able to lay out their issue. It helps when, like I said, they bring pictures, they bring the video, they bring their writings. So the first time the tenant addressed or gave notice to the landlord, I can look at their text or on their email chain that it was 5 months ago. Then the landlord responded with this. Then the tenant responded again 4 months ago and said this. And then the landlord still didn't do anything. Like, give the judge an idea of what it is that the problem is. Because we are not there, we are not seeing the conditions of the property. Help us help you. Same with the landlord. If the landlord has attempted to get access into the property and the tenant has refused, the landlord should keep a writing of that. Because what's going to happen is the landlord is going to say, I tried to get into the property, and the tenant is going to say, no, he didn't. So, in this day and age, like you said, text is more frequent, and that is fine. But help us help you on both sides, the landlord and the tenant. All right. Does anyone have any questions?
And John, is there, I see, I'm looking at, did you look at the chat box? I see a couple things coming in here.
So there is a question from someone. They would like to know, what are the tenant landlord rules now due to COVID? Do either one of you want to address that? Don, Angela?
Yeah, I had responded back to that one that I needed more information to be able to understand. I don't know if that, are they speaking about the CDC moratorium being no longer being in effect?
It looks like, the further explanation is, I received an eviction due to the landlord wanting to move in family. Lease was about to be up, but COVID-19 came. Landlord hasn't pressed issue yet. That was the further explanation.
Okay, well, I'll say that, again, the CDC moratorium is up, so there are no protections per se for non-payment of rent. The CDC never did cover anything outside of non-payment of rent. In the very beginning, there was a moratorium on any tenant being evicted from a property, but that was still very much at the, like that last summer. And then once that ended, like that was at the beginning of COVID. Then when that ended, it became, the CDC order only applied to the non-payment of rent. I see that the person just responded that they're still paying rent. So it's not a non-payment of rent case. And before, if there were other violations or if the lease term was over, then the landlord could evict the tenant. With the CDC moratorium being over, then we don't even have that. So if the lease is up, the landlord can bring the tenant into court and file an eviction.
Judge, if I may, I hesitate giving any legal advice here, but I think just to highlight the issues. Number one, I get the impression that notice of the term was not going to, I'm assuming that's what the issue here is, was end of term, and notice was given that it wasn't going to be renewed. The issue then is that notice still effective? And then secondly would be, what's the provision within the lease for renewal, renewal of that lease? For example, if it was a 1-year lease, then, and there's no provision as to requiring it to end and then going to a month, if that provision isn't there, well, then it's another year. So there are a couple issues here, and so I would recommend that this person consider consulting with an attorney. And because the conclusion could be that the fact that this landlord has continued to accept payment of the rent, that the lease is renewed for how many times, and then that can affect what notice now has to be given. So it's an interesting question. It's a bit probably more complicated than what the tenant realized, and that all the more reason to consult with an attorney.
Yeah, Don, I wasn't looking at it from the standpoint of, is this, most of the leases that I see after the year goes to the month to month, but that is it's not necessarily, that's not necessarily so. And so it would depend on the lease.
Let me just add too, I think one of the problems so often, and I have this with just a regular real estate transaction, is the communication. It sounds like if the lease has been is up or towards the end, and now that landlord has let them continue to live there, it sounds like that she should, if I'm Dawn, she should go back to the landlord and find out what the landlord wants to do. Is a landlord now looking to allow them to stay longer? If it is going to month, it all goes back to what does the lease say? Or what is, in the end, what are they looking to do? Because it is hard to find rentals right now. So honestly, if I was renting, I'd rather know sooner than later if the landlord is still intending for me to move out, and how long of a time frame would I have? And I find that most landlords will work with you if you go to them and say, it's hard to find rentals right now. How long, when you're looking to move in here? Try to buy themselves time, because it is hard to find other places to go. But I think in the end, good communication is where you should start at this point, and reread your lease to know what your rights are.
That's a great way if we're going to end this program. That's great advice. No matter what, read your lease, because as you pointed out, that has effect on the warranty of habitability if their lease or notice requirements set forth there. And then if it requires written notice and that has to be mailed, that whether that's proper or not, another issue. But then that allows the landlord to come in and say, you didn't give me the notice that is required by the lease. But whatever the issue is, before you take any action as a tenant, review that lease.
And as was already mentioned, the Berks County Bar Association has a lawyer referral service in which tenants or landlords can call and set up an appointment with an attorney for a consultation. I always say it's between $40 or $45. I really need to find out which one, but it's between $40 and $45, and you can speak with an attorney and get those initial questions answered. Any other questions? No. Any final words, Don?
No, I don't have any further advice other than what I just said. Read the lease, and if it is a habitable issue, remember what you have to do. Give notice, and be able to document that you gave notice, and allow a reasonable length of time, which can vary with the season of the year or the issue that's involved. And then set that money aside if you do withhold your rent and to force the issue. And always consider having an attorney.
I agree with all the above that he said. I think, reading the lease, if it was me listening to the last two that we've done here, I would say the biggest things are reading your lease, knowing, understand it, ask good questions, have a property manager if you're not living locally, and call an attorney when you have issues that pop up that you cannot resolve on your own. Absolutely.
Great. Well, I thank you both, Don and Angela, for participating today in our second series. I again want to thank our sponsors, the City of Reading Human Relations Commission, as well as the City of Reading. We also had the Community Outreach Committee of the Berks County Bar Association and the Realtors Association. Thank you all. And be on the lookout for the next part of our series on landlord tenant issues. Have a great day, everyone.
Thank you.
Thank you very much. Have a wonderful day.
Stay safe.